You got your coffee, you got your glass of water, and we're ready to start. Thanks to all of you, the participants, the speakers, the resource people, for holding on through the long haul of a conference that I can't even remember how many weeks it is. But it's always nice to see you, and I think the sessions have been useful. This session is one that came as a request from some advocates working in the area, talking about best practices for dispute resolution and RTB hearings. I'm just going to briefly acknowledge that we are on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh peoples. We know you are working throughout the province in different territories, and appreciate your work there. I'll introduce Michelle briefly and then just let her start. If there are questions throughout, what we're going to do is, if they're relevant at the time, I'll pop onto the screen and get Michelle's attention and ask them for her, but otherwise we'll probably hold off until the end for her to get through the presentation and then talk about questions. So Michelle has worked for many years as an advocate. She has a law degree, but has worked at North Shore, First United, and now is working at TRAC. So she's got a varied experience in many areas of poverty law, and we're really looking forward to having this session. Thank you, Michelle.
Oh, you're welcome. So I have quite a long PowerPoint to go through, and we've tried to just kind of cover quite comprehensively everything you have to think about when you're dealing with a residential tenancy issue that's going to go to dispute resolution. So I have a little disclaimer here that I'm not a lawyer. I'm not providing legal advice, and just generally I'm going through the rules set out in the Residential Tenancy Act and the RTB's rules of procedure. I'm not going to be talking about the Manufactured Home Park Tenancy Act very much. Most things that I refer to have a kind of corollary in the Manufactured Home Park Tenancy Act. So I have two screens happening here, so I have to sort out where I'm pointing. So dispute resolution is a legal proceeding for resolving landlord-tenant disputes. They're facilitated by the tenancy branch. So this is a branch of government that's in charge of residential tenancy law in BC. It is a type of court. It's an administrative tribunal. It's less formal, and it's done over the telephone, but still both parties provide evidence and make their case sort of one party at a time. And then an arbitrator makes a decision that's legally binding, and they can issue monetary orders, which are legally binding. The standard of proof is a civil standard, so it's a balance of probabilities, which means more likely than not, or 51% or more likely that. So the onus, the burden of proof is on the applicant in these cases, except where the applicant is a tenant who's disputing an eviction notice, at which point the burden of proof shifts. The landlord has to prove that there is cause for eviction, and the landlord then goes first in these proceedings. So again, the decision maker is called an arbitrator. Arbitrators aren't bound by previous RTB decisions. They should be persuasive to an arbitrator if the facts and circumstances are similar, because, the legal principle that decisions should be consistent. They are bound by relevant court decisions. Court decisions, generally speaking, are BC Supreme Court decisions that came up on judicial review. So somebody got an RTB decision that they didn't like. They were able to bring it to review. The standard of review is very high, so those aren't all that common. But in situations like that, you can bring those Supreme Court cases as binding precedent on an arbitrator. So the first thing you are going to be looking at when someone comes to you with a residential tenancy file is assessing the case. So you want to be looking at the information and evidence that they've given you and kind of making an assessment as to what they want to do, what's happened, what they want to do, what they hope to achieve, and make a determination as to whether those goals are realistic, and whether there's any real likelihood of success at achieving those. You're going to need to figure out right off the bat whether the RTB actually has jurisdiction. Where this most commonly comes up is, in my experience anyway, is where the tenant is renting a room, say, from the owner of the property. So that can happen where somebody owns a house or a condo and they're just renting out another room. If the owner shares a kitchen and a bathroom with their tenant, they're not covered by the RTA. Whether or not they are covered, you can also look at whether there's other options that should be explored before going straight to filing for a dispute resolution hearing. So those are issues just like, has the landlord actually tried to work, or the tenant tried to work this out with the landlord? If they have and they haven't been able to, is there any value in you acting as sort of a third party negotiator to try and advocate for a good solution for the tenant? The other thing you need to do is make sure that the tenant understands all the options that are available to them and the possible outcomes. So the tenant understands, for instance, if they've received a 2-month notice for landlord use and they file to dispute it and they're successful at having that set aside, they then will no longer be, if they decide to move because the writing's on the wall, they're not going to be eligible for the compensation they would have been entitled to, the 12 months rent compensation, had they moved out under that 2-month notice. The next thing you want to look at is whether a hearing's been set. If so, is the tenant the applicant or the respondent? And if they are the applicant, you especially want to look and make sure that they have served the landlord properly with that notice of dispute resolution, as well as whatever evidence that they filed along with the application. Some other things you want to think about in terms of kind of a merit assessment of the case are, if there isn't a realistic prospect of success, whether there might still be some benefit to the tenant in helping them at a hearing. So, for example, you might have a tenant who's filed to dispute a cause eviction, and the evidence looks like the likelihood may be that the tenant will in fact be evicted. But there may be a role for you there just to ensure procedural fairness, to make sure that the tenant does have an opportunity, if they have any sort of defense as to what's happened, that they have the opportunity to present those. And also, you may be in a better position than the client to make submissions to the arbitrator about maybe why a the arbitrator should grant the tenant a longer period of time to move if the tenant's disabled, or there are other factors that the arbitrator should be taking into consideration when they decide whether to issue a 48-hour OP, or whether it would be reasonable to give the tenant until the end of the month or the end of the following month. And sometimes tenants will ask whether the basis for determining whether to take their case is whether there's a likelihood of success. In fact, I think the calculus is more whether there's a prospect of any benefit to the client. So in most cases where a tenant is likely to lose, there isn't going to be any benefit to the client. Sometimes in a case like a 10-day notice, unless the tenant has actually paid their rent in full within 5 days, they're not going to be successful at hearing. But it would postpone the point at which the landlord would be able to get an order of possession and remove them from the premises. So the other thing you can look at doing is a limited retainer. So you might be able to help the tenant prepare for their case, or you might be able to give them some summary advice about the outcomes, or about what kind of argument they might be able to make. But what you do need to do, whatever you're doing, is make it clear to the client, to the tenant, what it is you've agreed to do, and especially if you haven't agreed to do something. So if you've agreed to help with summary advice but not to represent them at a hearing, then you want to spell that out in a retainer agreement or retainer letter. So then the other aspect of this is assessing your own capacity or your own abilities, and deciding whether you are the right person to take on this case. Do you have enough knowledge? Do you have the capacity in terms of time? So are you able to spend enough time preparing evidence or submissions, or preparing the tenant in order to be able to meet the deadlines for submission of evidence? And if you on assessment think that you don't have time, or you don't have the capability or the capacity to do it, it's important to get on that very quickly and let the tenant know, and know that it's okay to say, no, I can't help you with this. If you can refer the tenant on to somebody else who can, that's great. But if their case has no merit, there's no prospect of success, and there's no real benefit to the tenant for pursuing something, then it's also helpful if you can tell them that. If you can let them know, you're entitled to get a second opinion, but in my assessment, whatever your assessment is. So if your tenant comes to you and they haven't applied for a hearing, but they are going to, or they want to, then the main information you need to know is whether they can meet the application deadline. So in a general way, the general limitation period is 2 years in the Act for anything that doesn't have a specific deadline built into it. Evictions have specific deadlines built in, and they are short. For a 10-day notice, it's 5 days, 10 days for a 1-month notice, 15 for 2 months, and 30 days for the newer 4-month notice for demolition or renovation. I usually let people know that it's not a great idea to wait 2 years from the end of the tenancy. You're going to lose witnesses, and your recollection is not going to be as good. It's harder to get evidence together. You also can't sort of sit on your hands and not do anything if something the landlord is doing is causing damages to accrue. So there is an obligation under the Act for either party to minimize or mitigate their losses as much as possible. if you have mold growing in your unit and on your belongings, you could wait until 2 years after the tenancy ended to try and make a claim. But you would have to show that you had done something to try and mitigate that damage while it was happening. I'm just going to spend a little time on the issue of limitation dates for applying to dispute notices, because they're quite rigid. It's one of the key things that tenants and people who are helping tenants mess up, because they look at the deadline and they see 10 days and they think, well, that probably doesn't include weekends. Or they think, oh, this, it says somewhere that if it was posted on the door, I get 3 extra days. In fact, the deeming provisions that do exist for things like if a landlord puts something on a tenant's door and the tenant doesn't see it right away, they're deemed to have received it 3 days later. But if the tenant did see it on the same day, and especially if they mentioned it to the landlord, that's the day they received it. And if they then in hearing it turns out they didn't file until 13 days after they received the notice, it's likely that the arbitrator will set aside the tenant's application to dismiss. There is room. Arbitrators do have discretion to extend a limitation period, but they rarely do. The policy guideline basically says that if somebody was hospitalized the entire time of the deadline and they have something on hospital letterhead explaining why they couldn't get somebody else to file for them, anything short of that is not successful. Very often the reasons are because somebody, they got bad information. The tenant got bad information from somebody. They thought that it was business days and not calendar days. They assumed that because there was a holiday that intervened, they would have extra time. The only 2 cases that I can recall in my experience where a tenant was given extra time was in one case where the tenant had been basically clubbed in the back of the head and was out in a hospital until a couple of days past the deadline, and they had the hospital records to prove that. And the other case was where a tenant was served a notice when she was out of town in another city. She and the sister that she was visiting both got sick. The sister fell into a coma. She had organ failure, and the tenant in question ended up being named as a substitute decision maker. And she had all kinds of information and a letter from the hospital social worker saying that basically she couldn't leave the hospital. So those are the kind of reasons that an arbitrator will consider extending a deadline. So I've kind of dwelt on that for a long time, but it's very important, and it's hard for people to believe. It's hard for tenants to believe when they come and see us and say, well, okay, I missed the deadline, but it was only by 1 day, or it was only by 2 days. How can they possibly not hear my case? Unfortunately, the answer is they very often won't. So how to file? People can file in person at an RTB office or a Service BC Center. The small branch RTB offices are closed now. The main office on Kingsway is still open. They won't let you sit down and talk to them, but they will let you drop off an application form. Mostly people file online. There is a $100 filing fee. If someone is low income, they can apply for a fee waiver. And if somebody's on income assistance, they they will always be eligible for a fee waiver in my experience. It's tied to the low income cutoff. So it changes every year a little bit, and it is dependent on how big a city a person is living in and how many people there are in the household. It's important to have the right legal name and address of the respondents that you're naming, particularly if there's a monetary order at stake. We very often do title searches for people to make sure that they have the right legal owner. If a tenant's not sure who to name, maybe there's a landlord, there's an owner, there's a property management company, some corporation that's involved, we usually recommend just naming everybody. And then they can ask to be removed as a party. The arbitrator can make a decision on that. So we talked about this a little bit, but after a tenant applies for a hearing, the RTB will schedule that hearing and produce a hearing package. Contains a notice of hearing and a whole bunch of information and instructional sheets. The tenant needs to serve that on all the named parties within 3 days of receiving it. There are limited service methods for these dispute resolution proceeding packages. You can only serve it by sending it registered mail or hand delivering it. So it can't be left on a door or left in a mailbox the way other documents can. It's hard to know when a hearing will be scheduled. Typically, I think they try to schedule eviction hearings within 5 weeks. The RTB tries to save hearing dates for expedited hearings so that if somebody goes in with an urgent matter, they can hopefully get a hearing within 2 or 3 or 4 weeks. At this point, we've been getting eviction hearings scheduled for 10 to 12 weeks away. So I think the branch is quite busy right now, but that's sort of the order of priority for hearings is urgent issues like urgent evictions or tenants wanting orders of possession, urgent repair, emergency repair matters, and then eviction hearings, and then monetary claims. And sort of standalone claims for monetary damages are often not scheduled for 4 to 6 months away. So getting into the preparation for a hearing, again, we have some important deadlines. And again, there's very little flexibility around these deadlines. If an applicant or a respondent, if either party is late serving evidence, the arbitrator may decline to look at it. So an applicant's evidence has to be received by the RTB and respondent at least 14 days before the date of the hearing. The respondent evidence has to be in at least 7 days. So that makes sense for most cases. It's a bit weird with eviction cases, which is what most of our hearings are about, because the applicant in an eviction case is the tenant. So weirdly, the tenant has to submit their evidence rebutting whatever proof the landlord has that there's cause for eviction a week before the landlord has to submit their evidence. It seems really unreasonable to me, but that's the way they have it set up. If there's a cross application, then that evidence also has to be received 7 days before the date of the hearing. So that calculation of when those days come up are that counting those days doesn't include the day that the evidence is received or the day that it was, or the day that the hearing is set for. So I'm just going to go to a little calendar here. I don't know if everybody can see that. But so if your hearing date is March 26th, the respondent's evidence has to have been received by the applicant and the RTB 1 week plus a day. So 7, they sometimes call them 7 clear days. There has to be 7 full days in between the date the evidence is received and the date of the hearing. So you can see there the respondent's evidence on the 18th and the applicant's evidence would have to be in the hands of the other parties on the 11th. So what that also means is that if you're going to serve the evidence by registered mail, which is how we usually recommend people do it, that has to be sent 5 days before the hearing. So that's not 5 clear days. So it's the 5th day after sending. So for the applicant whose evidence is due on the 11th, it would have to be put in the mail on the 6th. Just going to go back to where we were. Okay. Some other deadlines are that amendments have to be received at least 14 days before. If the parties decide they want to adjourn the hearing, they can do that. The request has to be received by the branch. It has to be in writing, and they have to receive it 3 days before the hearing, at least 3 days. So that's 3 clear days before the hearing. And they always do require that request be signed by both parties and in writing. You can always ask for an adjournment at the hearing itself if you have some compelling reason to do so. You can make an argument. The other party will have a chance to argue why the hearing should not be adjourned. So again, the service deadline is the day the other party gets the evidence. So depending on how it's served, it may take different hours. So if you can put it in the person's hands on that day, they received it on that day, that's fine. If you have to leave it in their mail slot or post it on their door or send it by fax, it's deemed that they received it 3 days later, unless you can somehow prove that they received it on that day. Usually that would be that they acknowledged that they received it. So the tenant got a phone call or you sent an email saying, hey, I put the evidence on your door. Did you get it? They say yes. By mail, it's deemed to be received 5 days later. Registered mail usually comes the next day or 2 days, next business day or 2 days later. And if you can show proof of that, so if there's tracking and it shows that somebody signed for it on that date, then that's the day that they will be deemed to have received it rather than 5 days later. So what kind of evidence might you be serving? For those of you with legal training, the kind of common law rules of evidence don't apply. It's up to each arbitrator to determine what evidence they will accept. I have certainly made arguments at hearing about hearsay and that it would be improper for an arbitrator to accept as evidence a report from one party about what a third party who's not there said. So, in general, the concepts of what evidence will be considered are that the evidence that's relevant, reliable, authentic, complete, and legible should be considered. And what you want to be thinking about as an advocate is, based on the facts of the case and what either the tenant or the landlord has to prove, what is the easiest and best way? What are the things that will show the arbitrator what we need to show them? So one way you can do this is making a list or a table, setting out what you need to show or what you need to disprove, and then what evidence you could use to support that or to prove those points in the next column.
Hey, Michelle.
Yes.
Sorry, I'm lagging behind. I caught a couple of questions.
Okay.
I should have asked earlier. Okay. So someone is asking if there's any way, these are about filing, any way during COVID for the fee waiver if you're filing online.
Yeah, the fee waiver can be done online as well. For a while, at the kind of the height of the pandemic, they were actually just asking if the person was affected by COVID and had lost income due to COVID, and they didn't even ask for any supporting documents. But typically, what you want to have is either the tenant's, income assistance stub or their CPP stub or something that shows they're on fixed benefits, or I can't remember if they ask for 2 or 3 months worth of bank statements. And they ask for what the household's family income is and whether they're dependents. So that can be done online.
Okay, sorry, I have a stash of other ones. Someone is also noting that while they're harsh on applying and dealing with the fee by the deadline, that they've experienced that there's some leeway when a client makes an error regarding service of the dispute resolution packages.
With the dispute resolution packages in particular, I have seen a little bit more flexibility. I think because the other party will have received it so far in advance of the hearing that it's not really that prejudicial to the other party if the person was a day or two late disputing it. What I have seen too is where a person wasn't sent the notice of dispute resolution properly, but they find out about the hearing some other method. They call in and the hearing is adjourned to a later date. So that, could work in favor of a tenant. I feel like there was another part to that question.
It just felt leeway. No.
Okay, and there was something about a fee waiver. So I've had cases where a tenant filed in time, but they didn't have their fee waiver in, so they filed on the last day. They were able to get the fee waiver in the next day, but their application to dismiss the eviction was set aside. The arbitrator found that there weren't extraordinary or extenuating circumstances that made them late filing, even though the tenant had what I thought was a very reasonable explanation. He had disabilities, he had a lot of barriers, he'd sought help from Advocacy, and there was just a misunderstanding or a miscommunication that he needed to get that fee waiver in the same day. He was able to, it was the end of the day and he wasn't able to get the information from the ministry. So even though he filed his fee waiver, the day after the deadline, his application was dismissed.
Yeah, that actually seems to correlate with what the comment was. They're strict on the fees, but a little leeway on other issues.
Yeah, and a lot of people don't understand it. It's a bit confusing. It says you have 3 days to submit a fee waiver after you make your application. It goes on to say that those 3 days don't extend a deadline, but a lot of people don't quite put that together. So they think, okay, well, I filed, I got my application in on time, and now I have a 3 days, 2 or 3 days to get my fee in, or my fee paid, or my fee waiver in. But in fact, the application is not considered complete until the fee waiver or the fee is paid.
Okay. Someone else wanted clarification about what else besides emergency repairs could be considered urgent. I think you had a list of them.
So a tenant's application for an order of possession, if they got locked out by the landlord, that's about it. An urgent repair issue. So something to do with heat or power. If a tenant, there's rules under emergency repairs that says a tenant can pay for a repair if it's an emergency, and the landlord would have to reimburse them. But if a tenant doesn't have $25,000 to repair a roof that's collapsing, then they would file for an urgent hearing, and hopefully get a hearing within a few weeks.
Okay, and one final question in this area is, someone is asking whether others are experiencing arbitrators not receiving materials, even though they have been submitted electronically with registered mail receipts.
I haven't had that happening personally. I have had hearings where the arbitrators had a real hard time finding documents and finding the evidence that was uploaded. And I've had some very long, uncomfortable stretches of hearings where the arbitrator's going back and forth with the other party about what the file name was of the document that they uploaded. I will say that it does seem like the arbitrators don't have the best experience with that system of uploading evidence, because they very often don't seem to have the evidence that they need in front of them in a reasonable way. And my assumption is that that's because they're sitting at home, they're logging onto some kind of portal, and they can see documents that they then have to click on and scroll through. I don't know. If that does happen, though, you would have the applicant would have the proof that it was uploaded. Hopefully, if they printed out the receipt or emailed the receipt, it should list the documents and their names and when they were uploaded. In a case like that, where the arbitrator was saying they didn't have the evidence, I think it would certainly be reasonable to then ask for an adjournment. Because the arbitrator and the other, should be able to consider that evidence if it was properly uploaded.
Yeah, it sounds like it's happened to a couple of people, but anyway.
Yeah, and if that is happening, then it's also worth contacting the branch or the director and letting them know that that's happening.
There's actually a bit of a chat going on in the Q&A where a couple of people have had this experience, and someone else has said they're never filing online again because especially when they have a lot of evidence, I guess because of the problems with the system.
Yeah, I have a little bit on uploading evidence to the branch because this has been an issue. And they have a very confusing system where you go to the upload site and it's like has a bunch of issues, and then it asks you if you want to submit proof for this issue or that issue. And what I have been doing is putting all the evidence together into one PDF file. So I compile all the documents in the order that I want to send them in. And I add page numbers. So they're just, all those pages are just numbered sequentially. The PDF has to be smaller than 10 megabytes. So if it's bigger than that, I either optimize or compress it, or I break it into 2 PDF files. I give that file a consistent name. So if it's 1, I just call it tenant evidence. If it's 2, I call it tenant evidence page whatever to whatever and page whatever to whatever. I then, if I'm doing written submissions, I make that a separate PDF. I include an index of the evidence with the page numbers and what the documents are. And then when we're in the hearing and the arbitrator is saying, well, where is this thing that you're talking about? I can say it's page 41. It's the file called tenant evidence. And it's at, so that there's one thing that I can refer the arbitrator to. This came out of a hearing that I had where in the decision, the arbitrator complained about how poorly organized the tenant's evidence was and that it hurt the tenant's case. And I was like, how dare you? Because I had very carefully and conscientiously uploaded like all the individual bits of evidence into the different issues. So I had some correspondence with the branch after that, and that's basically what they told me, is that the preference is to have a single document with page numbers, even though that doesn't work with the way they have their upload system set up. It seems to work okay for the arbitrators. So then the only other thing I upload is I will make usually one PDF where I will compile all the proof of service document. So if I have, an image of the stamped addressed envelope to the landlord, and then the tracking number and the tracking.
Mm-hmm. I think someone is just proposing what you've just outlined, submitting the evidence in one package. They were suggesting one package in addition to submitting them individually. But you're saying really the one package properly indexed.
Just do the one thing, because then my sense is, and again, partly this going on in the theater of the mind when I'm in these hearings and listening to the arbitrator trying to find stuff, is that they just have a confusing welter of documents that they're trying to figure out. And I can't see how it could possibly be helpful to them to have the same. I had done that before, uploaded the same document to different issues, or having the same document in two different places. But now I just do the one package, one PDF.
Okay. Finally, on this issue, and there's another one, but we'll leave that till later. Someone's asking, if you're asking for an adjournment because of the evidence not being uploaded, are you likely to get it?
Well, I would think so. If the arbitrator is saying, "Oh, I don't have the evidence," then how can they proceed with the hearing? If you're saying, well, my the tenant's giving evidence, and they're saying, and I have the follow-up email conversation at page 3 of my evidence, and the arbitrator's not able to see that, they're not recording these hearings. I don't know how they could proceed without the evidence.
Mm-hmm.
I mean, you might have to tell the arbitrator that. You might have to say, no, this is very important. We need to be able to refer to this evidence. You need to be able to see the evidence.
Okay.
But who knows what an arbitrator is going to do in a hearing.
Okay, I can hold off the rest till later.
Okay, so different types of evidence, basically documents or testimony. So the typical type of documents you might be providing are, if it's about the security deposit, the condition inspection report. By default now, if you file online, the RTB insists that you upload a tenancy agreement, even if you don't have one, which is quite frustrating. But you might have photographs or copies of emails and text messages. As far as testimony, so you are allowed to call witnesses. Witnesses will be excluded from the proceedings until they are called. But in order of kind of priority or reliability, I guess, sworn testimony given by a witness at the hearing is kind of the gold standard. The witness is there, they're available for cross-examination. The other party can challenge them on what they've said, and they can respond. The next best thing is a sworn affidavit or a sworn statement, swearing that what they're alleging is true. And for this reason, it's helpful. Many advocates are eligible to be commissioners for taking affidavits. The next best thing would just be a written, like a letter that was dated and signed. Digital evidence can also be used, and basically what that means is video or audio recordings. If you have photographs, digital photographs, I think it's generally just as well to print them out in color, to reproduce them so that they can be looked at on a page. So we talked about this a little bit earlier about evidence, that it has to be, in order for it to be considered reliable, it has to be sort of accurate and complete. So evidence may not be accepted if it's hard to see or hard to hear, or if it's been edited and it's not clear what's been chopped out. When you are submitting evidence, you should keep in mind that in order for the arbitrator to consider it, technically every piece of evidence should be referenced at the hearing. So usually how that comes out is through the tenant giving their testimony, describing what happened, and specifically referring to the evidence that they've submitted. So with digital evidence, you have to use certain devices to serve it to the other party, and they have a list, I think, of acceptable file types. So there's a digital evidence details form that you have to complete, and you do need to confirm with the other party that they can actually access that digital evidence. And you should do that as soon as possible. It's a little bit, it's kind of a funny thing, because in some cases it feels like you're almost inviting the landlord to say, oh, no, sorry, I couldn't read it. I couldn't open it. What I've been doing is including a letter or sending an email. If I've been communicating with the landlord by email, the letter basically says, here's the digital evidence. These are the file types that I used. I was able to view it on a PC, in VLC, in Windows Media Player, like naming the applications that I was able to view it in. It was viewable on a Mac using QuickTime and VLC. And then just saying, if you have any difficulty viewing these files, please let me know right away, and we will email you a copy, or we'll give you a Dropbox link. And then I upload that letter into evidence as well. And then I feel like it's harder for the landlord to say, oh, I couldn't open it. I couldn't read it. And it may be helpful to keep in mind that the arbitrator's never going to look at this video or audio evidence that you uploaded unless you do specifically make a point of saying, we look at this video clip at this point in the video, this is what you see, this is what you hear, that kind of thing. So organizing evidence, I've already kind of gone over what I do to make a PDF file to upload for the branch, but the evidence should be organized, clear, legible. Both parties need an identical copy, which is, used to make more sense when you gave the paper evidence to the branch or faxed it to them. Given that they have this thing set up where you just upload random files into different things, I don't see how that's supposed to work, but that's, I think, another good reason for just having one PDF file. You then print it out, give one copy to the landlord, upload the other copy to the branch. Everybody knows when you say tenant's evidence page 6, everyone's looking at the same thing. So the format I usually use is that there's a page that has all the relevant information, the RTB file number, the hearing date, the names of the parties. That I usually have that front page also includes a table of contents, an index of the evidence. Most of the time I do produce a written submission as well. That's a document that's sort of 3 to 5 pages long. The format I use is laid out on that slide there. I'll write, what the issue is. Tenant wants the landlord's notice and their tenancy set aside. I will outline the facts of the case, referring to the evidence. And then set out the law that I think applies. Usually what that is the sections of the act that are in play, the policy guidelines that pertain, any relevant case law. And then, the argument, the analysis, why in this case the law supports the tenant's position. And then the conclusion, the requested remedy at the end, for these reasons, the landlord's notice should be set aside and the tenancy reinstated.
Michelle, there's a couple of questions about evidence.
Okay.
Someone is asking about requesting or compelling, getting a copy of the tenancy agreement from the landlord if the tenant never had a copy of it in the first place.
Right. So, yeah, TRAC has a template letter that that we usually recommend people use to request a copy of the tenancy agreement. There isn't anything like the landlord had to have given a copy of the tenancy agreement within 7 days after signing it or whatever, but there's nothing else specifically in the Act that says a landlord has to give a tenant a copy of their own tenancy agreement. But an arbitrator would think it was very weird if the landlord had refused to do that for some reason. So if the landlord's being difficult about it, that's not going to look good on them at the hearing.
Okay. And someone's asking, you may just have been answering this, but do you submit the written submission at the same time as the evidence? You submit it as a package?
Generally speaking, yes. There are times when you may not want to do a written submission at all, particularly when you have a party on the other side that's like a bad actor, somebody who is, for instance, liable to manufacture evidence in order to rebut whatever claims or statements you've made in the written submission. In cases like that, what I have done the reason I like to have a written submission most of the time is if it's a complicated case, if there's legal argument, if there's a lot of evidence, the hearing's only an hour long. I like to have everything written down and the references to the evidence and the explanation of the legal argument so that at least after the hearing, the arbitrator has that there in front of them. The only reason you might not want to have it is if, like I say, if you know the other party is a bad actor. Sometimes what I have done is uploaded the written submission and sent it to the other party just a few days ahead of the hearing. And what I've done in that case is I've said, to the other party, and I'll upload the same letter or email to the branch as well, saying, to be clear, this is not evidence. This is a written version of the argument that we will be making orally at the hearing, and I'm just providing it to you ahead of the hearing as a courtesy. And I've never had an issue with that. I did have one landlord that I was involved in a number of cases with, who tried to object on the basis that I wasn't allowed to email them evidence. But I just reiterated it. It's not evidence. It's argument. Normally it would be made orally. It's all laid out here in writing ahead of time to make things easier to expedite the hearing.
Great, thanks.
Here, this is just back to submitting evidence. Yeah, we just have a note here saying the downside to written submissions is you tip your hand to the opposing party, maybe more than you necessarily have to. It's usually more beneficial to have all the arguments and all the facts and evidence laid out ahead of time than not to, in my opinion, in my experience. Again, it depends on the type of hearing. If it's a very straightforward eviction hearing and it's just a matter of the tenant giving their side, their version of events, and trying to undermine any claims the landlord has made, there may not be any real point to written submissions. Okay, client preparation. So well before a hearing, I usually go over a fair amount of stuff with the clients, particularly how a hearing operates. So I let them know, it's at this time. We both have to call in. I can't call into a hearing without you. You call in 2 or 3 minutes ahead of the hearing. Hearing's going to last about an hour. I'll explain kind of the format, like it's an eviction. So the landlord will go first. They have to try and prove their case. They'll have about After the preliminaries are over, they'll have about 20-25 minutes to make their case. You can't talk when the other party is talking. Save your criticisms for when it's our turn. We will then have the opportunity to give our evidence, to cross-examine the landlord, any witnesses. And then each side will have an opportunity to kind of respond, make closing arguments. And then that will be the end. I make a point of reiterating that the tenant absolutely can't talk when one of the other parties is talking. And then apart from that kind of procedural information about how the hearing will go, I will go over the evidence with the tenant. So all the things that I think it's important for us to present to prove the tenant's case. And then we'll go over, it's not always clear how a hearing is going to go and whether you're going to have the opportunity to sort of do a formal cross-examination of the other party or formal direct examination of your witness. But generally what I try to do is come up with sort of a list of questions that I would ask the tenant to elicit the evidence that needs to come out at the hearing for the arbitrator to hear. So sometimes those questions will just arise out of the back and forth of the hearing. Sometimes the arbitrator will ask questions, but we will talk about that evidence that the arbitrator needs to hear about in order to make a decision. So it's important not to, you don't want to coach your witness. You don't want to be putting words in their mouths. But it's reasonable to go over the questions, to talk about the evidence, the tenant can practice describing what happened and referring to the piece of evidence that they need to refer to. So preparing any witness, so either your tenant or their witnesses, go over the questions that you'll be asking and potential cross-examination questions. So if they say something that's in dispute, that the landlord has one version of events, the tenant has another, then you can help them figure out, what are they likely to ask you? What are they going to challenge you on? It's important to tell them to tell the truth and to try not to exaggerate. It's very hard for people when they're in these fraught circumstances, especially if there's a lot of tension or hostility with the landlord, to sort of try and make the landlord sound worse, which then undermines the tenant's credibility. I always tell people to listen to the question and think about what they're going to say, and that if they don't know the answer, to say they don't know, or to say they don't understand, or to say that they don't remember exactly. And also not to say too much, just to answer the question, and then give an explanation if there's follow-up questions or if it's not clear, and to stay on the topic, to just answer the question that's being asked of them. And not to say anything abusive or hostile while they're giving their evidence. Witnesses, as I said, will be excluded. So if someone's not a tenant, they're just somebody who was witness to something that happened, they will not participate in the hearing until it's time for them to give their evidence. If somebody is being called as a witness after they've been sitting in the room the whole time, you can make an objection to that, because it's just a basic principle that witnesses shouldn't be able to tailor their evidence to what they've already heard. Yeah, so as far as preparing for yourself, if you've had to do a written submission and prepare the evidence, you're probably familiar with that evidence and with what you need to do. And if you've prepared questions for direct examination to go over with your witness, then you'll be prepared for that as well. You should have some idea of what the landlord's case is if they've submitted evidence. So you can think about what areas might come up that you could examine. You could cross-examine the landlord on. And then you might want to write out a kind of a general closing argument with, what you hope will have been established in the course of the hearing, knowing that may change depending on what evidence does come out. Hopefully nothing too surprising. And again, you want to refer to key pieces of evidence in that closing argument. So you can also be prepared with procedural requests. Someone had asked about adjournment. So if you think that there's a reason that the hearing should be adjourned, you think it would be reasonable, then you can think of what arguments you may have about why that's necessary and why it doesn't prejudice the other party. If there's any issues of late evidence or late filing. Translator, there's a point here. There can still be in-person hearings with the RTB. I've only ever done one once, and it was because the tenant had a stroke and had really severe aphasia, lot of difficulty with communication, and had like an aid basically that helped him to speak. Otherwise, generally the RTB doesn't like to do them.
Michelle?
Yes.
Someone is asking about accommodations for someone who's deaf.
Yeah, so that's another example where an in-person hearing might be appropriate.
Okay.
I'm not sure if they have any other kind of, I don't know that much about the technology that's available, but I think that possibly it would make most sense to request an in-person hearing.
And another question is, what do you suggest people do if they are acting both as an advocate and as a witness? For example, if they're testifying that they were denied, that the landlord denied the advocate's request to provide access for the tenant to get their possessions.
If it's a very limited thing like that, like if it's one thing that the advocate is giving evidence about, I think it's reasonable to make an argument that a person could act both as an advocate and as a witness. But yeah, generally speaking, if you're acting as an advocate for someone, you can't also be a witness on that person's behalf. Mind you, I mean, as an advocate, I always get sworn in because I do give evidence about things. I often give evidence about service, for instance. So yeah, if what you're giving testimony about is very narrow in scope, you could hope that the arbitrator and the other party wouldn't object to you being both technically a witness and also an advocate.
Yeah. Okay, that's it for now.
Okay. So I've already gone over kind of the typical structure of a hearing in talking about preparing your witness. The beginning part of the hearing is always 5 or 10 minutes of everybody spelling their name, saying whether they're with someone else. Everybody gets sworn, and then it's the applicant's turn, or the landlord in a case where the applicant is disputing an eviction. The respondent challenges, so does cross-examination if that's going to happen, and then presents their own evidence. Then the applicant can respond and can make kind of their final argument or statement, and then the respondent can respond to that and make their own closing statement. Honestly, it doesn't always really happen that way. Sometimes the The arbitrator gets very involved right off the bat and does a lot of the questioning, and will just ask back and forth, both parties. It's a bit weird, but it does happen. If you are in a situation where that is happening, just make sure that, if you have sort of your list of evidence that you want to get across, that everything that does need to be asked and everything that does need to come out has actually happened. And if it hasn't, then you can say, well, I have some questions to direct my client's evidence, if you haven't otherwise had an opportunity to do that. Sometimes what happens too is that there's no time. The arbitrator is running out of time, and they start to get very impatient and cut people short. I had one case where the landlord didn't finish giving their evidence and doing everything they wanted to do until 11:54 or whatever. And the arbitrator, they didn't put much pressure, but they did suggest that it would be great if I could get our evidence in those remaining 6 minutes. You can, it's very reasonable in a situation like that to say, we cannot get all our evidence in that time, and we will need to adjourn the hearing if it can't go over. So, start of a hearing. Yeah, in the old days, I always had the client with me in the room. It's very difficult to run a hearing where it's just two disembodied voices, you and your client on the phone. But now that is how that goes. So I do have, the submissions, the evidence in front of me. I try to make sure the tenant has a duplicate copy, that we both have copies of kind of the questions that we're going to go over. So when you call in, they give you the access code. It tells you to say your name and then press the button or whatever. I usually say Michelle Beda, the advocate, and then I say the tenant's name as well for the tenant, blah, 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 and then press the number. If this doesn't come up so often anymore, but if the arbitrator suggests that, there's a problem with you speaking for the, or helping the tenant or acting as an advocate, you can refer to RTB policy guideline number 26, which set out really clearly that it's perfectly appropriate for a tenant to have an advocate. Got behind in my notes here, sorry. There's something about advocates. Oh, okay, so there's a note here that says you may prefer to refer to yourself as the agent as opposed to the advocate. This is because that policy guideline distinguishes between advocates and agents and says that agents have authority to make decisions and settle disputes, which may be necessary. So if you think that that's going to come up, we do this by practice anyways, that the tenant signs an authorization for the landlord and the RTB so that we can submit ahead of time.
A couple of more questions, Michelle. Someone is asking, if you're seeking a monetary order, is it appropriate for the tenant to ask the landlord to be required to give their full legal name at the hearing and then ask that the application be amended to reflect that legal name? Yes.
Yeah. Yeah, that's a good idea because they are under oath. And if they refuse to do it again, it's going to look very weird and it would be recorded in the decision.
Okay, another question from back a while away, but still about submissions. Do you put your written submission on your letterhead?
No, I'm just visualizing the template. No, I don't. I put my name at the bottom. I say, Michelle Beda, advocate for the tenant, blah, 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 and I date it. But no, I don't use, there's no reason not to. I don't think. I just don't. Our letterhead takes up a lot of space.
Okay, thanks.
Okay. So yeah, be prepared to take notes as best you can. I find it very difficult to take notes in the course of a hearing because I'm busy. It's nice if you have a colleague or a coworker who can sit in and take notes with you. That's obviously that doesn't always happen. But you just have to do your best to try and keep track of what's going on because there is no other recording of this hearing. If it does go to review or judicial review, it's very helpful if you have good notes about what happened, what was said. So off the top of the hearing, think about the procedural issues we talked about before. If there's any evidence issues, if there was late evidence to deal with, or if you want to make a pitch to adjourn the hearing, now is the time to do it. I have raised the issue sometimes off the top at a hearing about if I think that a notice is so deficient that it should be set aside, I will ask if I can make those arguments at the top of the hearing, because if it is deficient enough, the arbitrator should be able to say, "This, we're just not even going to bother having the hearing. This is such a bad notice." It's a good idea they make everyone say and spell their name, so it's a good idea to write those down so you have that for your notes. They will usually ask, but in quite a great amount of detail about the service of evidence, when it was served, how it was served, when it was received. So just be ready. That's the other thing that I usually have in front of me is the proof of service information that usually I've uploaded to the branch as well, but just showing what date, when the notice of dispute resolution package was ready, when it was served, how it was served, when the evidence and submissions, if those were sent later, when they were done. And the tenant will have to be prepared to answer questions too about when they received the notice, when they received the evidence. It's good to have that all written down ahead of time. So when the landlord is giving their evidence, this is a time when you particularly want to take good notes. Make a note of anything that you want to cross-examine them about or talk about. Don't interrupt and don't let the tenant interrupt. The exception that's named here is if the landlord starts talking about evidence that you don't know what it is, you haven't heard of or seen, it would be appropriate at that point to interject and just very apologetically say, "I'm sorry to interject, but we don't have that evidence." And then usually the arbitrator will get involved and go through and try and sort it out. The arbitrator, like I said, may ask questions of the landlord and their witness. If they have asked those questions, don't re-ask them on cross. Like if the arbitrator has already noticed deficiencies and they've asked the landlord about it, you don't need to go over and ask them again. So the two goals of cross-examination are to identify problems with the evidence. So anywhere you can point out an inconsistency or a gap, or if you have some evidence that something they've said is just wrong or exaggerated. And then attacking credibility. So if there's reason to believe that landlord is being dishonest, or they don't know, or they've just made a mistake. And it's okay not to cross-examine if you don't think you'll get anything useful out of it. Generally, kind of the main rule of cross-examination is not to ask a question you don't already know the answer to. And typically the way you ask questions are not really to ask a question, but to make a statement and say, isn't it true that, so if they've said, well, the tenant never told me about this issue, then on cross-examination, you might say, well, but isn't it true that the tenant sent you a text? You can see that text at page 12 of the tenant's evidence. That you're not really asking a question. You're just getting them to concede that, they've said something wrong, or they've lied or made a mistake. Yeah, the other note is trying to ask questions that allow the landlord or witness to explain themselves, although the arbitrator will often ask that too. But yeah, basically, traditionally cross-examination is sort of making a statement and then getting the landlord to endorse that statement without going into some explanation or excuse as to why that might have been. For direct examinations, you can't ask those kind of leading questions. You have to ask open-ended questions. You can, if they haven't given the evidence that they need to give, you can ask a follow-up question, but you can't kind of point them to the answer in the question you're asking. You can refer them to their documentary evidence and get them to talk about it. Yeah, it says here testimony should be firsthand and not hearsay. So it's not that helpful generally to have your tenant say, well, I heard so-and-so say this or that, rather than just saying, well, I was there and here's what I saw. And yeah, again, both the landlord and the arbitrator can and will ask questions as well. So oh no, I just have a couple notes about previous file. Yes, generally advocates don't give evidence. I've already given examples of times when I have about service and that kind of thing. But you can refer to documents when you're making your submissions, when you're making your arguments, to explain to the arbitrator how you want them to use them, why they're relevant. And yeah, it says here, I'll sometimes refer to documents during direct examination without putting them to the tenant, and that seems to be just fine. Like in court, that wouldn't fly. But yeah, I think in a hearing, they're short. The arbitrator really just wants to get through all the information evidence. They often don't mind if it's you rather than the tenant who points out a piece of evidence or refers to it. So your closing statement, you may not have a real opportunity to make one, but it's useful to have, a couple sentences at least written out ahead of time. This is where you would make your sort of legal arguments or submissions. Try to be concise. Lay out the structure of your closing argument. Like I say, usually it's just a few sentences, but you can say, I'm just going to show 3 things. So this is where you would be referring to the law and the policy guideline and the case law, and saying and the evidence and testimony, and tying them together. And if you are referring to evidence at this stage, as at any stage, say what page it's on and give the arbitrator time to catch up. And explain why the evidence says what it does and why it's relevant. So at the end of the hearing, the arbitrator usually signals really clearly that they're done and that they think everyone has said everything that should be said. And they will usually ask, if anyone has any questions, unless something really important has been missed. The answer should be no. There are usually thank yous all around. The arbitrator will sometimes ask how the decision is to be sent out. If the tenant is agreeable, I usually ask that it be sent to my email address, and that way I'm sure that I will get it as soon as it arrives. And yeah, arbitrators' decisions are legally binding and enforceable. I don't think we've talked. One thing that comes up quite often during hearings is the opportunity for a settlement discussion. Sometimes this comes up kind of organically because the arbitrator gets a sense that there's a possibility of a settlement. Sometimes the arbitrator will push very hard at the beginning of a hearing for the parties to settle. And this can be quite disconcerting to tenants. I've had arbitrators say things like, well, tenant, if the landlord is successful here, you'll be out in 48 hours. That can be very alarming if you haven't, talked about the possibility of settlement. The tenant is the parties are under no obligation to settle. Often where this comes up is in a contested eviction, where the arbitrator just wants to see, well, if the tenant agrees to move in 2 months, can we come to that kind of agreement? So talk to your client about that ahead of time. Ask them, if the question of settlement does come up, would you think about whether you might be willing to settle, what terms you might be willing to settle on, if you're given 3 months and $500 for moving expenses, and kind of what the top and bottom of that range might be. An arbitrator can kind of step out of their role as decision maker and step into a role as mediator to help you negotiate a settlement. It's very weird and not really appropriate, but that is how it works in the RTB. And if the parties do come to an agreement, the arbitrator can record a settlement agreement sort of instead of a decision. So you'll see those sometimes when you look on the RTB decision website, is just some recorded settlements. Is there a question, Lois?
Yes. Someone's asking if there's monetary orders against tenants, how do those usually get enforced by the landlord? And what about orders against landlords? Is this maybe what you're coming to? Yeah,
that's probably in, there's probably some talk about enforcement. No, maybe not. We might as well just talk about it now. Yeah, so a monetary order of the RTB is enforceable as an order of the court in provincial court. So the first step after somebody gets a monetary order is what we recommend anyway, is they serve that monetary order along with a demand letter saying, I would like to be paid in full within X amount of time. If it's a tenant's monetary order and it's an ongoing tenancy, usually the arbitrator will direct that the award be kind of deducted from rent. So the tenant doesn't pay rent until the monetary award is satisfied. If it's after the tenancy or if it's in favor of the landlord, then the party can take that monetary order to small claims court after they've served a demand letter and haven't got the money. They go and file it in small claims. It's a small sum of money to file that can be added on to the award, along with you're entitled to court, like interest as set by the court. And then there's a few different mechanisms through small claims court that can be used for enforcement. If it's against a tenant and a tenant is indigent or very low income, then they may effectively be judgment proof if they get, if the order is filed in small claims court and the tenant can't pay, the tenant can ask for a payment hearing before a judge. Payment hearing would happen. The tenant would show that they had no money, and the judge may order that the tenant pay $10 a month or maybe nothing because they don't have enough income to support a repayment plan. But there's it's a small claims court issue. There's a fair amount of information online on enforcement of monetary orders. People can do things like garnishee bank accounts, garnishee wages, or put liens on properties, for instance.
Someone's asking how interest is calculated.
Don't know. It's set by the court. They have some kind of formula, I think.
Okay. There's a question from a while ago about an issue. Someone's asking whether you've had experience with a tenant being evicted from subsidized housing on the basis that they weren't eligible for subsidized housing.
Yeah.
And if you've seen success in any of those cases.
In cases where the eligibility had to do with the subsidy, with the amount of rent they were paying, no, not much. Those cases are very hard because subsidized housing providers are excluded from certain provisions of the Act, and arbitrators can't scrutinize subsidy decisions. In cases where, I'm trying to think of any specific hearings I've had, not many with subsidized housing, you can often negotiate something with the landlord. They're very tricky. If you have tenants in subsidized housing in Vancouver, we have a new advocate here, Lassa, who's funded specifically to help low-income tenants in the city of Vancouver. So if those issues come up, you can refer people to Lassa. I feel like I really didn't answer that question, but
it's a hard question to answer.
It is.
Now someone else is asking about enforcing an RTB order that is not a monetary order.
So there's a new compliance and enforcement unit. I've had some success engaging them with things like locking tenants out or threatening to lock tenants out. That's what they're there for. They're there for if a landlord isn't complying with an order. So it's a pretty easy process. You go online, there's a couple-page application form. Anyone can submit it as long as they attach a name to it. So advocates can submit them on behalf of tenants. The compliance and enforcement unit actually investigates. They will call the landlord, they will call the tenant, and generally how they get compliance is by calling the landlord and saying, you have an order and you have to do this thing. And if you don't do it, then we can start fining you up to $5,000 a day, I think is the limit on fines. So in talking to them, they've said that generally speaking, they get compliance by just outlining the consequences of non-compliance to landlords. You can also file for another hearing and ask for compensation.
One more question. Sorry. Someone said they haven't been able to get any action from compliance and enforcement, and it's been over a year. There's only 4 of them, and they are very busy, but I'm not sure if, like I've usually had a call back from them within a few weeks of submitting something, even if they're not able to get to it right away. But I've also only made applications in cases where there's pretty serious non-compliance, where they were threatening lockouts or where they weren't turning the heat on. So maybe it depends on the issue. I don't know. Would this be a situation where if someone's having trouble with compliance and enforcement, they phone TRAC, or is that something your office deals with?
I mean,
I'm thinking of it as a systemic issue.
Yeah, you could let us know if you haven't heard anything. We're involved, and I know we're involved in this kind of periodic roundtable meetings with the RTB. So if there's systemic problems, we bring it to their attention. I try to encourage people to use that compliance and enforcement unit because I'd like them to hire more people. It's, sort of seems to have started off as like a pilot project, and maybe the branch thought that there wouldn't be that much need or demand for those services. But I do know that there's only 4 of them, I think, and they're dealing with the whole province. So, and they've had some very like huge investigations files that have taken along, like multi-building issues and stuff. So I do know that they are busy.
So, Michelle, we're at 20 minutes to the end. There's a couple of questions. One about things we're discussing now, and one sort of broader ranging.
Okay. Well, let me just click through the rest of these as really pretty quick, I think. So once a decision is issued, there are 2 routes for review. The first one is an internal review at the RTB. They're really limited in what you can review things on. One is the person couldn't attend the hearing. Has to be due to circumstances that couldn't have been anticipated and beyond their control. So those are things like a massive power and internet outage through a whole region. They were never notified of the hearing because the landlord never served them the dispute package, that kind of thing. Second one is the person has new and relevant evidence that was not available at the time of the original hearing. And what that means is not that the tenant didn't submit that evidence because they didn't know it would be needed or important, but that it was literally not available when the hearing was held. So that would be like a document that was not produced until 2 weeks after the hearing. And finally, that the person has evidence that the decision was obtained by fraud. And that's difficult because you have to actually prove the fraud. You can't just say the landlord was lying. So very narrow grounds for review, and reviews are rarely successful in my experience, even when I think there's merit. Very short deadlines, and again, difficult to prove fraud when you only have 48 hours from receiving the decision to get all of your evidence together and submit it to the branch. So the 2-day deadline is for a notice to end pertaining to non-payment, an early end, or an order of possession issued for any reason, or a landlord withholding consent to assign or sublet. 5-day limitation for a notice to end for any other reason. But again, if there was an order of possession attached, that has to be done in 2 days. Repairs and maintenance, or terminating or restricting services. Otherwise, it's a 15-day review period for any other matter. If a review is successful, there will be a new hearing. Basically, the review arbitrator will say, okay, I find that whatever there was fraud. That never happens, and they'll set it down for a new hearing. So the other thing is a judicial review, and the bases for judicial review are to do with procedural fairness. So if there was something unfair about the proceedings, and it might be a situation like the landlord gave all their evidence in the first 50 minutes and the arbitrator only gave the tenant 10 minutes and then didn't want to adjourn so the tenant could give all of their evidence. That would be a breach of procedural fairness and the party's right to be heard. So, or their decision is patently unreasonable. So those are the grounds for seeking a JR at Supreme Court. The test for JR is very high. That standard where a decision has to be patently unreasonable. That's because the RTB is considered an expert tribunal. Patently unreasonable means more than just unreasonable. The decision can be unreasonable. It just can't be so extremely unreasonable that like the reasons aren't connected to the evidence. So again, with a review at Supreme Court, if a review is granted and the party is successful, there will be a new hearing at the RTB. The judge at Supreme Court won't sort of substitute their own decision for the decision of the branch. So there's some information there on dispute resolution. The rules of procedure are online. The TRAC website has a section on dispute resolution. You can also find some material on dispute resolution, including videos, I think, on the RTB's website. And then that's the end, and here we are for questions.
Sorry, I'm popping up. Here I am.
That's okay. I never know where the questions are.
Yeah, I found the questions.
There we go.
I just couldn't find the mic. Question was whether it's reasonable for the RTB to make an administrative penalty at a dispute resolution hearing.
I think that technically they can, but I've never seen that happen. I don't know, I guess is my answer to that question. I've had hearings where in the decision the arbitrator has said that, administrative penalties could be applied against the landlord, but they didn't apply them themselves. I mean, I guess before, administrative penalties were handed out so infrequently until the compliance and enforcement unit started that, it comes up never.
Okay. Okay, the last question for now, unless others pop up, is that someone had a client who, without the advocate's knowledge, taped a conversation with the landlord, and it showed that the landlord had lied about the reason for the 2-month notice. The question is whether that sort of evidence can be used in an RTB.
Yes, it can. Canada is what's known as a one-party consent jurisdiction. As long as one party to a conversation knows that the conversation is being recorded, it's perfectly legitimate. The tenant wouldn't need the landlord's permission to submit that as evidence. The reliability of the recording might be called into question by the landlord. The landlord could try to deny that was them talking, or depending on the quality of the recording. But no, I've submitted exactly this kind of thing in exactly this context. A tenant recorded a conversation with their landlord because their landlord kept changing the story about who was supposed to be moving into their unit. And so he had a recording of a conversation with the landlord saying that his nephew was going to be moving in or something.
Okay, and they don't have to tell the landlord either at the time or before the hearing?
No, I mean, they have to submit that evidence 2 weeks before the hearing, so the landlord will have notice of the evidence and, be prepared to try and rebut it.
I think that's it for questions, unless more come in.
Okay.
Just checking. What is the contact of your colleague?
Oh, Lhasa? You can just call. What's the best number to call?
You know what? We could put that. Call. Okay.
He is new, so I don't have his extension memorized. We have an intake person. So people could call Anna, who's our paralegal, and she does intake for the programs. And she would be able to do the intake for Lhasa. And her number is, can I type it somewhere? Yeah, I could put it in the chat, right? I'm going to type an answer. Contact 604 extension 230, and that's Anna. Intake. And then Lhasa is the.
I guess you can put it in there, could you?
Oh, there we go.
Okay, any other questions? No, there's no other questions. Wait, Becky, so since we have a little bit of extra time, do you have any comments on what a tenant can do when a landlord gets an order of possession?
Well, if there's any grounds for judicial review, they could try and get help to file for a judicial review and a stay on that order of possession, on any pending writ of possession would forestall the eviction. If there's no grounds for review, and I'm thinking the most common case where there wouldn't likely be grounds for review would be if the OP was attached to a non-payment of rent eviction notice, because those are, it's almost like a strict liability offense. Like if you didn't pay your rent in full within 5 days, that's it. An arbitrator can give a notice or an order of possession. Yeah, I mean, sometimes a tenant will get an order of possession from a landlord, and the landlord will, the tenant or an advocate can still negotiate with the landlord around the ending of the tenancy. Because sometimes the landlord might like to avoid the cost and inconvenience of having to file for a writ and hire bailiffs and deal with the tenant's belongings. Sometimes if it's a 48-hour OP or something, the landlord might be willing to let the tenant stay until the end of the month or longer, or, accept prorated rent on a for use and occupancy basis or something like that. I'm not sure if that really answered the question.
Yeah, that's a general question. There's another couple of questions. Yes, Becky, yes, they say it did. Someone is asking whether you could send a sample of your written submission and an evidence submission, like an anonymized precedent.
Yeah, like I could put a template. How could I do that, Lois? Could I
We could put a
template
on SCED, and then we could include it in the materials.
Yeah, I can do that. Evidence submission would be a bit trickier because it's always evidence, but it's literally just like I take all the PDFs of all the different things, and we have a program called PDF Exchange. You can do PDF editing in Adobe, but I think you have to pay for it. You can do some limited editing in Preview on the Mac, although I'm not sure if you can add page numbers. But yeah, the evidence submission would just be just a bunch of different documents with page numbers. When I print them out for our use and for the landlord's use, I usually tab them. So I'll put numbered tabs in between the documents, and I'll include tab references in the index on the submissions as well, just to make it a bit easier to flip through. But otherwise, in the PDF format, it's just a bunch of documents. But yeah, I can anonymize a submission template.
Great. Okay. And is your PowerPoint already up on SCED or not? I
uploaded it last night.
Okay.
But last time I had a presentation, I thought I'd uploaded it as well. So Lois, maybe you can just let me know if it's not there, and I can re-upload it.
Yeah. A lot of people are sending their thanks via chat. Thank you very much.
Very good.
Good outline of everything.
You're welcome. I feel like I was kind of rushing through, but I guess it was a lot to cover. I don't know.
Good. Yeah. No, people were saying from the beginning it was very helpful.
Good. Yeah, it's hard to know exactly. People are kind of at different levels. It's hard to know exactly what specific information people are going to want. So we try to just cover the whole process from beginning to end.
Well, and this gives people something to go back to as well. And a precedent would be great.
Yeah, okay.
Okay, well, you can, oh, there's a Q&A. I wonder, no, it's just everybody's just generally saying thank you. Good. Well, thank you very
Okay.
much. We're
Yeah.
done. Bye, everybody. We'll see you Thursday.
Bye.
Bye, thanks.
Thanks.